going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm rich.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right, I've got some good ones for you. Before we get into them, a couple things. I've been messaged a few times from last night's members only. I did take it down. I made it private. I said I was going to during the Judge King clip. I don't want that video being out there. If there's a member that wants to see it that was halfway through it when I took it down, send me a message. I changed it from private to unlisted, so I will send you the link. But yeah, I just don't want it being out there. I don't want people to copy it and put it out. I want the story to die, right? Judge King's coming back next week, so just let it die. We'll all move on. Second thing. Oh yeah, I was supposed to be playing an Eric Martin video tonight. There was supposed to be a jury trial that I was invited to not participate in, but watch. But unfortunately, that case was adjourned. He applied for another attorney, so they adjourned it. So we're going to have to wait for the next adjourn date. And once it's scheduled, I will let you guys know, and we'll watch it then. But didn't happen today. Okay, now that the news is out of the way. First clip is out of the DDC. I want to say a giant thank you to HCC and No and No. You guys both let me know this was going on. Oh, and it's a good one. It's a good one. So thank you both. And Wixom, no. Eric Martin is not still in jail. He did bond out. So he's not in jail. All right, let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Your name, sir? Good afternoon. Your name? In the blank?
Right to the right?
You have, what's your name, sir?
Draven Romero.
Good afternoon, Mr. Romero. Or Sir, no, Romero, thank you. This is case 24058-934, People State of Michigan versus Draven, Serna-Romero, also known as Draven Romero, Draven Serna. Appearance for the people.
Jennifer Douglas for the people, P72748.
On behalf of Meadow, Your Honor, waive the reading stamp duties, been advised of his rights.
Thank you. Court waive formal reading and plea of not guilty. Mr. Serna-Romero, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, August 28th. Wednesday, 8:30, 36th District Court, Judge Giles. You have a right to a preliminary examination in person following Wednesday, September the 4th, 8:30, 36th District Court, Judge Giles. Understood? You understand your court date times?
I refuse.
Refuse what? Okay. All right. Well, your court dates have been given to you. That's the bond from the people.
I go in person, right? Can I have my courts in person? My 2 court dates, can I have them both in person?
Sure.
And the one from... So I'm getting charged with...
Okay, Mr. Serna-Romero, let's stop. You're not just talking out. You'll have your chance, and now's not the time. So be quiet, listen. I'll give you a chance when it's your chance. Now's not the time. In person, August 28th, September 4th. APA Douglas, that's the bond.
Your Honor, Mr. Serna-Romero, the people are going to ask for a bond of $50,000 cash or surety tethered house arrest. Mr. Serna-Romero just had another case in front of this court last month in July. I did handle that arraignment. It is now at Third Circuit Court, where he's charged with GBH and aggravated assault. The date of offense was July 9th to 24. In that case, he was given a $50,000 personal bond with the tether I did check the register of actions. I don't see that the tether was removed. I know it's not always updated, but when he was arraigned, there was a tether, and the register of actions doesn't show it was removed. So now we have him allegedly going to a house where he wasn't supposed to be because the PPO had been served, and
So APA Douglas, I don't mean to cut you off. When was he arraigned? Yesterday?
no, Your Honor, he was
Right.
arraigned July 25th of 2024.
And this is the same complaining witness?
No, Your Honor, this is a completely different person. The other
Okay.
people were neighbors and a neighbor's friend. So,
Okay.
and it's different addresses. He was told he couldn't go back to the address he was at in the other case. So the address that we have in this case is different from the other case. Your Honor, so he appears to be on tether on bond in an assaultive case and allegedly going to a place he's not supposed to be at because of a PPO. Officers indicate in the report that they actually saw him leaving the scene on a bicycle. Your Honor, and defendant is alleged to have said in the presence of the police that he would go back to this person's house, Your Honor. And so we do have concerns that when there's a PPO in place, when somebody's already been given a personal bond and tether on an assaultive case, that they would say in front of the police that they were going to go back to a house where they are not allowed to go. So, Your Honor, we do think there's danger to this complaining witness. We think there's a danger to the third party witness who indicated to police that he was afraid to give a statement because he feared for the safety of himself and family. So we do believe that if Mr. Serna Romero is given a personal bond or anything less than tether house arrest, that there is going to be this danger. A court already tried giving him a personal and a tether, and that apparently, I know it's allegations, but he was allegedly seen by police at the location and said he's going to go back. So, Your Honor, we have concerns about assaultive behavior, and we're asking for $50,000 cash or surety with tether house arrest to ensure that Mr. Serna Romero is kept away from this complaining witness.
Thank you. Response, Mr.
All right. Before Mr. Reagan jumps in here, yeah, I know, no, you don't like Mr. Reagan. He does try hard. He's just very good at victim blaming. And listen to what he's about to say. Also, before I do play, Sparkle Pimps, thank you so much for the $2 super chat. I appreciate it. 12 was president accounted for. Do it. You do it. All right. Thank you so much, Sparkle. Let's go.
So I don't know about a GPS tether and no contact. I know that there might have been a PPO, but it's like Mr. Romero feels like he's the one being set up. They give him, they say they text him, they say come meet up with him after they want to serve him with a PPO. Hey, you come here.
You're breaking up, Mr. Reagan. I want to hear what you're saying, and you're breaking up, Mr. Reagan.
I think disingenuous. Now I will. Can you hear me now?
Yeah, that's better. Thank you.
Okay, I'm sorry, Judge. I just think that it seems a little disingenuous, as Mr. Romero says. They put a PP out on him, then the next day they text him and say, "Hey, we want you to meet. Can you meet up?" So why are you putting a PPO on me and then saying, "Hey, would you meet up with me?"
Let me ask. I want to be clarification. It looks like, and I apologize. Correct me. The PPO was served July 20th of 2024. Then this allegation took place August 18th, about 6 weeks later.
Okay, well, Judge, it's my understanding that the date, there was a PPO in place, correct. But then you call after, as the court said, the PPO was served first, then these allegations happen after. Then you call me to say, meet up with me once you've served me with the PPO. Why are you saying, hey, come meet up with me once the PPO is served? You shouldn't want to have any contact with me whatsoever. And it's
Is this in the investigator's report I'm missing, or is this what your client told you?
Well, that's what my understanding is, Judge, of what.
Okay, because how I read it, it's the complaining witness stated that the defendant was texting and making threats, and then apparently showed up to the location and then assaulted and harassed and fought people. That's the allegations I see. I just didn't want to see if I missed it. If I did, please point it out.
understand what the write-up says, Judge, and I
Thank you.
just want to
Thank
know,
you.
I just want to point out, Judge, my client, he wants, to get some help. He needs to get his meds. He needs to get some meds. He wants to go to the hospital. And I don't know, they haven't given him, he hasn't had food, he hasn't had water. They've given him this blue vest to put on. But he needs his medication, Judge. I mean, he's not going to have contact with her, and he says he's not going to have contact, doesn't want to have contact. And I think that would suffice.
I thank you. And please mark Mr. Serna Romero's file medical reasons stated by counsel. Continue, Mr. Reagan.
Judge, and the biggest part, Mr. Romero feels like they set him up, Judge, for this. And he is not trying to bother this person, not trying to stalk this person, but he feels that's his feeling.
Okay, thank you.
And Your Honor,
Okay,
I just
so
want to be clear.
Go ahead. Okay, Douglas.
I wasn't saying that the personal bond with the tether had to do with this complaining witness. I'm just saying he has another assaultive case with personal on the tether as opposed to control assaultive behavior. And then here he's allegedly violating a PPO.
Gotcha.
Right, the PPO is against this complaining witness. And I thank you both. And so I have a number of concerns. He's out on bond on assault matter, unrelated complaining witness. But we do have in this matter is apparently a valid personal protection order served 6 weeks before. Mr. Serna Romero was told not to have any contact with this individual. Apparently, he continued to text her. Apparently, he showed up at this location in violation of the PPO. And apparently, he does want to have continued contact, though he may have told his counsel otherwise, but according to investigators' report, in front of the officers, it's alleged that he stated on camera that he will keep going back to this person's house regardless of the PPO, I'm guessing, and regardless of a court order. This was on allegations on camera of the officers that he's going to keep going back. And that's even before he's seen me. But there's still a PPO in place, so there's no reason to ever say that. And then when he was at the location, of course, this escalated, but he shouldn't have been there, into a fight. And it became assaultive.
I didn't fight them though.
Okay, so Mr. Serna Romero has been told not to come back or not to have any contact with this complaining witness, period. That's what a PPO is. Allegations you're in contact, but very concerning is apparently on the officer's camera, you stated that you will keep going back to the home. So I don't know what else to do than put a cash bond to protect this individual's safety. A personal protection order was given. That seemed to not help. You've apparently made statements that you're going to go back to the home. And so I do find, given the personal protection order, given the allegations of threats, given the information included in investigators' report, that you are, by clear and convincing evidence, a danger to Ms. Kemp. She doesn't want anything to do with you, apparently, but you won't.
All right. I wanted to wait till the magistrate finished talking before I paused, but the defendant's going to start talking over him, and I wanted to give you just a fair warning. It's about to get loud. There's about to be a lot of cuss words. Just heads up. I didn't bleep them out. You're going to hear them. Also, MB, thank you so much for the PayPal. I appreciate it. That is generous of you. And I'm really sorry to hear about your mom. Hopefully, everything works out the best way it can, but I'm really sorry to hear about your mom. Prayers for you.
Leave her alone.
Mental illness.
Okay. So for those reasons, bond is going to be set as recommended by the people, $50,000 cash surety. During this bond, there's no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. You're not to go anywhere near the Smart Street block in the city of Detroit. Nowhere near the complaining witness, Ms. Kemp. No contact with Ms. Kemp is no contact of any kind, orally and writing through a third party at her place of residency.
How the hell I'm gonna get 50,000? How the hell I'm gonna get 50,000?
I hope you don't, and that's intentional, and that's affordable to protect her. If I thought you had 50,000, I would have made it higher. And watch your language, you're in court.
I don't give a fuck. I have evidence of her calling me. I have evidence of her saying to meet me there. It's in my phone.
And
Y'all
so
want to see
bond
the
is
phone?
going
I
to
have
be
the
set. I'll
messages.
give you a chance.
I
Now is
have
not
the
your time.
messages. Give me
$50,000
$100,000
cash surety.
I don't give a fuck. I don't give a fuck.
That's
Fuck
going to
you,
be tether
fuck the
house
attorney,
arrest.
fuck all y'all. I don't.
Mr. Reagan, you don't want to say anything to your client? I mean, this is,
Mr. Romero, I understand what you're saying.
no, you want,
Like I said, Judge, he needs, he wants his meds. He wants to get help. He wants to get help. Mental
that's what
situation.
he could have said. He could have said just that, but I
No,
hear
but
you.
that's
I
what
understand.
I'm
I understand,
saying.
Mr. Reagan. I understand. Okay, so bond is said intentionally unaffordable, 50,000 cash surety, tether house arrest, no contact with Miss Kemp or the Smart Street block. And Mr. Reagan, that's unaffordable.
Yes, it is, Judge. Yes, it
I'm
is.
scheduling an intentional unaffordable bond redetermination. You're on mute, so I think what you're yelling and saying at this point is futile. But bond is said intentionally unaffordable, and you'll have an unaffordable bond redetermination hearing August 22nd. That's a Thursday, 2 days from today, via Zoom at 9 a.m. Chief Judge McConaughey's courtroom. That's not nice, Mr. Sterling Romero. Okay.
I love the magistrate's response to that. That's not very nice. That's not very nice. Yeah, it is. It isn't very nice. Put your hand down. Is anyone actually offended by that anymore? I don't know. When I see it, I laugh. Like, really?
Bond's intentionally unaffordable, 50,000 cash surety, tether house arrest. APA Douglas, anything further?
There's nothing further from the people, Your Honor.
Mr. Reagan, anything further on behalf of your client? Mr. Reagan, you're on mute.
Oh, I'm sorry. Nothing further, Your Honor.
Okay, and I hesitate to ask, but any questions, Mr. Sarah Romero?
Can
If
I
not,
talk to
you're
my
out.
attorney? Can I
Yeah,
talk
you
to my
can.
attorney?
Absolutely. Absolutely. Yes, yes. What camera do you want them at? Camera 4?
Hey, how can I go on tether home if I'm not allowed to go home?
Hold on,
That's
hold
You're
on.
gonna
my-
have to be tethered to another location. You're gonna have to be tethered to another location. You're gonna have to find somewhere else to be tethered to. You cannot go back to that
I
location.
can't
Can
go
we
to
go
the
on
mental
camera in the
hospital.
breakout room?
I can't go to
Okay.
You want to put them in there?
Yep.
Yeah, they're gonna talk.
Well, we have one more male, so you had another question. What'd you say, Mr. Romero?
No, it's no more males. It's only it's 2 females.
Okay, Elliot, Guandalalis Gwen is a
Can I
female.
can I get my courts in
Yeah,
person?
he's not here.
Can I get my courts in
that
person?
Yeah, yes, yeah, absolutely. I already told you
I
that.
don't
You
want
gotta pay
Zoom,
attention.
or I'm not going.
All right, well, then you'll get a warrant for your arrest, and it's in person. Elliot, Gonzalez, Gwen.
Yeah, they not here.
Okay, Mr. Reagan, I'm gonna put you in a breakout room with your client. I'm gonna go to the
And I'm
female
gonna still
side.
go back when I get out of here. And I'm gonna still go back when I get out of here. Fuck you and fuck you
Give me
too.
that.
Hold on. Wait.
Hear what I said? Fuck
All right,
you.
bond is going to be amended. I'm setting.
Give me 100,000. Give me 100.
No, it's going to be 150,000. I have no confidence that Mr. Sarah Romero is going to follow any orders of the court. So bond is going to be. What was that?
We'll do the redeterminate.
No, he wants to talk to his counsel. Yes, bring him back if he wants to talk to his counsel. And bond is going to be a set of 150,000 cash surety for those reasons.
I'll put him back in the breakout room. You want to talk to him over there?
No.
Back on this camera.
Stay right here, camera 2, right here.
Hey, big time. Come on, he want to talk to you right? Let's go. Here you go.
Give me $1 million bond. I don't give a fuck.
I'm satisfied at 150,000. I think we're good with that. Okay, go ahead, Mr. Reagan.
Yeah, that just happened. I don't really have anything else to comment about that. He tripled the bond. Who can't wait for... They still say in front of McConaughey, but Judge Williams has been covering the redetermination hearings. That'll be Thursday, and I'll be watching. We'll see how he acts. And if it's Vincent's going to call this out. He's going to call this attitude out, and it's going to be great. And how is Reagan going to defend it this time? All right. Again, thank you, Noah, and HCC. You both sent me that clip, so I appreciate it. I would not have had that without you. I was not watching the DDC today, so thank you so much. Okay. All right, now we're kind of going all over the place. I do not remember what's coming next, as always. Let's see, what do we got?
Mr. Estrada.
Judge Boyd. Welcome to the area, Judge Boyd. Purse is looking great. Flowers looking lovely. Your hair is looking great as always, Judge Boyd. Let's go.
All right, Mr. Estrada, it's my understanding you wanted to speak with me?
Yes, ma'am.
What do you want to speak with me about?
I want to speak to you about what's going on. Well, basically, last time I came here, you were talking about the habeas corpus. Reason why I couldn't get a motion for personal bond, making a bond, getting a bond, PR bond, or
No, I gave you a PR bond. A PR bond was given to you on July 25th, 2024. It was set at $3,000. I granted the PR bond. I waived the fees. There was partial GPS for employment only. I waived the fees of GPS. I did a referral to Center for Healthcare Services. I did random UAs, waived the fees, and sober support meetings 90 and 90 days. So I gave that to you.
I never seen anything of that.
No, you were here in court because let me explain something to you. In this court, I don't set bonds. When people come in and they say, oh, judge, can you set a bond? The state and I have an agreement. You know what I tell them? Is your client present in the court? I require, when I set bonds, for the person to be in court before me. So one, I can ask them questions. And I can tell you right now, I would not have said sober support meetings, referral to Center for Healthcare Services if I had not spoken to you. So that's information I obtained from you and from what's in the system in order to give you conditions of your bond. So you were before me. I remember you being before me, and you were given your PR bond.
I was given a PR bond when I was in District Court 175.
No, I gave you this PR bond.
I didn't get it. I didn't get released.
No, I gave you a PR bond. That's what I'm telling you.
I just got a bond reduction.
No, you were given a PR bond. Yes, you were.
It's a reduction.
No, a PR bond is, and I'm going to explain it to you in layman's term. Your bond was set at $3,000. I gave you a PR bond after receiving a report from pretrial services that said you were a good candidate for a PR bond. And so when I set your bond at $3,000, I gave you a PR bond. The fees were waived. That means that all you had to do was show up. You didn't have to pay a penny to get out of the Bexar County Jail. So you were given a PR bond, the fees were waived, and I ordered partial GPS. Partial GPS, I waived the fees. You didn't have to pay a penny for GPS.
What was that for? What was that for? When?
I gave you this on July 25th, 2024.
Well, I got a PR bond for 3,000 on what was it?
On cause number 2024 CR 7673, which is this case. And previously it was a night mag case.
This is a rearresting charge.
Mhm.
I was in district, like I said, this paper right here says in district 175.
No.
I got.
Are you looking at the indictment?
That's when I got rearrested. So that's when I got arrested for this charge.
No, that's the indictment. And so each court is given a grand jurors. And for example, that was probably when the 175th judge was over the grand jury. That's why it says 175th, but you've always been in the 187th.
They put a warrant for my arrest because they said I didn't show up. Like before last time I came by, you said I got GPS, I got a UA. Well, I guess I didn't show up making a phone call to when I got out from 175 at Kangaroo Court for this charge.
Mhm.
And they put a local warrant.
Mhm.
And they put a warrant for me, and I didn't know what was going on. So they brought me back here, and ever since then, last time when I came to this courtroom for the first time,
Mhm.
you said you give me the bond went up to 5,000 on the paperwork. It said 50,000, and I guess they made an error, I put a motion for a habeas corpus because it was failure to be ready, and then I guess on computer said you wanted to put it to pretrial services. You said the UA and the GPS monitoring.
Mhm.
I didn't get any follow up on that when I was in my unit, my pod,
Mhm.
about you know what I mean, a pretrial officer. You know what I mean? You said when you get out, please report to your pretrial officer.
Mhm.
And none of that. I was still sitting here and I was wondering who can I talk to on the kiosk about, oh, what is this, you know what I mean, there's GPS work release, the GPS, you know what I mean?
Mhm.
But there's no, you know what I mean, no follow back on that. The bond was originally 3,000. Then I guess when I went on the computer, when you asked the officer, it will show you, and it said it went up to 5,000.
Yeah, I saw that. That is awesome. Hello from Ohio. So glad that you're here. What's up, Sally? Hope you're doing well. All right. Yeah, this is just my normal pause. Try to pause it about every 5 minutes. So I don't really have anything to add. You guys have been killed in the chat. So let's keep going.
But it says D 175, but this is a re-arresting charge. It said it was 3,000. Now it went to 5,000. And then when I got that paperwork, it said from him, it said 50,000. I guess someone made a mistake. And what do you call it? I was
All
worried.
right, Jennifer, can you look up and see the reason?
Yeah.
Yes.
So it looks like on,
Are you able to print anything?
I'm gonna try, I do show that he had a bond, that he made a bond on, that was for $3,000. That was also a PR bond. That was back on June 3rd, 2024.
Mhm.
Now, prior to that, on April 1st, 2024, there was a setting of a bond of 5,000, but that was before that PR bond.
Okay.
So that's what I'm trying to look at right now to see what that five. But I do show where our PR bond was granted in the amount of 3,000, and that was on the 25th. And I do recall this because I was the clerk in the court
Yes.
that day.
Can you check November
That what?
of 2023?
There's nothing.
No, we're not doing November 2023 on this
That's
case.
the reason why. That's the reason
No,
why.
no, no. Where we start is July 25th, 2024, because every other bond on this specific case before that date doesn't really matter, because on July 25th, 2024, I gave you a PR bond. And that supersedes everything else. So let's just see.
But I was still here.
No, let's see. Who's outside the door? Do we know? I see white paper.
Just to give a little bond history, initially he was released on a PR bond.
And what date was that?
That was on November 23rd, 2023.
All right, let's start. Well, okay, we can do that.
And then he had a violation report.
So November 2023, I want you to listen. That was a PR bond. Then you had a violation report. When was that?
That was January 24th, 2024.
So January, you had a violation report.
Judge Nahida handled that.
Mhm.
And then it looks like he was continued on bond with the same conditions.
Mhm.
There was then a second violation report,
Okay,
again for non-report.
okay.
It was handled again and picked by Judge Nahida.
And what date was that? What year?
Still 2024.
Was it January?
Mhm.
Okay. So second violation.
Then there was a third violation report
Mhm.
on February 26, 2024.
Okay.
Again for non-reporting
Mhm.
and non-compliance. And looks like there was a hearing set on it for March the 5th, it looks like.
Mhm.
But then it was reset and then it was heard on March 19th.
Mhm.
Of 24.
Mhm.
That resulted in an increase to $5,000.
Okay.
His pretrial service was terminated unsatisfactorily at that time.
Mhm.
That increase was again by Judge Nahida.
Okay.
And He was arrested on April 1st, 2024.
Okay.
There was a few pro se motions that were sent, like reduction to state jail felony to misdemeanor. Motion for a bond reduction on June 17, 2024. A pauper's oath. And then we come to, and this was all in early July of
Okay.
2024. We come to the 25th, where he had a hearing.
Okay.
That was on the application for writ of habeas corpus for a PR bond. It was granted in the amount of $3,000. And that's where the additional conditions were set.
Okay.
So in essence, he never made that $5,000 bond.
Mhm.
It was then applied for that application for the motion for a PR bond, which we heard, and essentially, basically, you decreased the bond from that 5 to 3
Yes.
and granted it in the form of a PR bond.
Okay.
And waive fees.
Yes.
But Your Honor, like I said,
Yeah, that's the court coordinator, though. She's not usually on the record saying anything, so she wouldn't normally have a mic next to her. So that's fine. But that's who was talking right there.
All right, now, so I want you to listen to me. Number one, I'm sure, because I would not have done it, I'm sure that there was an issue with your case not being indicted. That's why you got the PR bond for me, because your history is you're given PR bonds and you don't report when you're supposed to report. So again, we're back to where I am, which is you never made a $5,000 bond. You never had to make the $5,000 bond. Judge Nahara gave you a PR bond and you had a violation. You didn't report. So then they continued you with your PR bond. And then again, you didn't report. And that was your second violation. Then they continue you with that PR bond. And then there was a third violation. Then I think there was a bond increase at some point to $5,000. And then I believe your case had not been indicted. So there was a request for a PR bond again, which according to the law, if that case was unindicted at that time, based upon the time, I would have had to give you a bond that you can make. And of course, if you're at the Bexar County Jail, you don't have employment. So the only bond you can make is a PR bond. And you were given that PR bond on July 25th, 2024. And I waived the fees. So basically, you were getting out of jail for free. Now, let me ask you this. Why is he currently in custody?
From what I can see, the directive was sent over to the jail. I'm not sure what happened on the processing side.
Okay. So has his PR bond, has he ever been out of custody since July?
25th?
no, Judge.
Okay, so what is happening? Why isn't he out of custody?
Odyssey says, search me. Yeah.
Okay, all right. So, Jennifer, do you need to call the jail and see why he's not out, or do I need to call the jail?
I can call them right now.
All right, they're gonna call them right now and see why he's not out.
Very well, Judge.
All right, have a seat.
Yeah, Your Honor. Yeah, I'm trying to, you know what I mean, follow up on, you know what I mean, just trying to, but like you said, on, you know what I mean, trying to remain sober, you know what I mean, get a job and all that. Just,
All right, so here's the thing. You've had a lot of chances to be clean and sober. And according to your history, you continue to violate your PR bond. This PR bond that was given to you, it was given to you because the case had not been indicted within a certain amount of time. I am telling you right now, if you are released and if you don't follow through on the conditions of your PR bond, then guess what? It's going to come back to me. I'm going to hear it. The other judge is not going to hear it. It's going to be me. Do you understand? So have a seat and she's going to call the jail and we're going to see what's going on.
all right, thank you, Your Honor.
You're welcome. Thank you.
Thank you, Judge. May I be excused?
Oh, just give me a moment. They're going to
Okay.
call the jail real
Okay.
quick and
Very
then
well.
he's going to get a reset date.
Okay, very well, Judge.
Your Honor, you might have stick around.
All right, that's it for that one. Yeah, that attorney didn't say a word. until, can I be excused? He just wanted to leave. It was kind of weird how that resolved. When they were taking everyone back to the jail, he was like talking to the judge as he was walking back, so it was kind of difficult to hear. But all that she said is, your attorney will be in contact with you. So that's all that we missed on that one. All right, before the next case, Jess, I know you're not a new member, but yeah, YouTube does that sometimes, and I still don't know why. But Jess, thank you so much. I'm guessing it's supposed to be a milestone that's more than 1 month, so thank you so much, Jess. I appreciate it. And yeah, the second I saw that come up, I knew that that's what your comment was going to be. Cheshire Cat, the name that I can never pronounce. Can't even pronounce. Cheshire Cat. Cheshire Cat. Cheshire Cat. All right. Anyways, thank you so much, Cheshire Cat. All right, let's go.
All right, and help facilitate the jail, we'll call People v. McLeod next.
Yeah, I was muted. This is the sovereign citizen that was on the boat. This is Judge Gauthier out of, I never remember where he is in Michigan, but he's in Michigan. And yeah, the sovereign citizen got arrested for contempt. Didn't show up to court. Now we actually get to see him in orange, but this is kind of funny. So I know OSG played this earlier, but it's worth sharing. So enjoy.
Good afternoon again, Your Honor. Custody on behalf of Trevor McLeod.
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me. What's Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed to that?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. So
I do see that the new charge is set for an arraignment on September 10th. It was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the
Well, lucky for you, I grabbed another one off his docket today. So we got 2 Judge Gauthiers in a row. So we have this one and then a guy who, not the best guy. He's up next.
Contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's the sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad advice. He's now retained counsel. To my knowledge, he had no failures to appear. He did fail to appear one time, which led to his incarceration and his sitting and bond being revoked. To my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had a lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gooders. People's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right, well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract and ignore the case. So this was really quite a willful.
He has an attorney now. He didn't have one while he was out. He was trying the soft sit stuff. Wasn't working for him. And now that he got arrested, did he say he was appointed or he was retained? I don't remember what the attorney said. But yeah, so he apparently dropped the act once he figured out he doesn't look that great in orange.
Refusal to acknowledge even the authority of the court and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear and now has an absconding charge. So his bond will continue to be revoked until the conclusion of these cases.
Thank you.
Thank you.
She's from a France firm.
All right. That's how you FAFO. Yeah, don't try the sovereign citizen stuff. It's not going to work. It's not. The best shot you have is the officer doesn't show up for a ticket and it gets dismissed. That's the best shot you have of getting a case dismissed with that nonsense. Anyways, you all know that. All right. We're staying in the same court. 2 back-to-back Gauthiers. Let's go.
All right, and let's call People v. Sayers. For sentencing and probation violation. No, I'm sorry. Yeah, sentencing, probation violation, sentencing in 3 files. 22-6457, 23-6764, and 23-6765. Counsel, you want to state your appearances, please?
Melissa Goodrich, Boone County Prosecutor.
Jeremiah Buffalo, we're on behalf of Mr. Sayers, who is seated to my right.
Okay, and have you had a chance to review the probation violation report?
Yes, Your Honor, we reviewed it some time ago. The court had been setting these matters out due to Mr. Sayers' other pending matters that are presently here in Sheboygan. We would ask that the court continue to hold that out so we can handle those other matters.
And my only problem with that is now it's alleged that he's committing crimes while he's in our jail, so I'd like to get him out of our jail. So I'm going to proceed with sentencing today. It's notice for sentencing today. Any additions or corrections to report?
No, Your Honor.
Ms. Goodrich, any additions or corrections to report?
No, Your Honor.
Or anything you want to say on Mr. Sayers' behalf?
Yes, Your Honor. Mr. Sayers is a victim of addiction, Your Honor. And addiction rears its head in many ways, and it has got a hold of Mr. Sayers. Your Honor, I believe that the best possible solution for Mr.
Yeah, I would love to play more of them. Gauthier only goes live maybe once or twice a week, so yeah. So I try to grab something that's interesting or good. This one is just this guy's a bad guy, and Judge kind of throws a book at him at the end, which is why this is here. I haven't seen Judge Oakley live in probably over a week though. Maybe I need to check to make sure I'm still subscribed to him. I don't know. I haven't seen him live in a little bit. Okay, let's keep going.
Mr. Sayers is to be engaged in treatment, and we would
I
ask.
think so too. And so I sent him to treatment and he walked off and absconded. So I don't know how to get him to treatment. I agree 100% with you. The problem that we have is that Mr. Sayers doesn't agree with you or me.
In my conversations with Mr. Sayers, Your Honor, he does. He acknowledges that these acts that are alleged are tied to an addiction, and he needs the help. So, Your Honor, we would ask that the court fashion a remedy that allows for rehabilitation as opposed to punishment.
Thank you, Mr. Sayers. It's not required to say anything today, but it is allowed. Is there anything you want to tell me?
I'd just like to say that what he said is 100% accurate. I do struggle with addiction. I definitely need help. I want the help. I mean, obviously I've struggled with trying to get there, trying to do it myself. But I have 2 kids that definitely need me, family that needs me. I'm disappointed in myself for everything that I've done. I want to do better. I guess that's all, Your Honor.
Let's get his recommendations from the people.
Yes, that's who Judge Oakley is. He's always standing. I feel like he might be one of the only ones that does that. But yeah, he's absolutely always standing.
Oh, yes, Your Honor, the defendant is 26 years old. He had 2 prior felonies and 6 prior misdemeanors before these cases. He was given a second chance by entering to recovery court, despite numerous warnings about taking it seriously and being ready for the program. Mr. Sayers has repeatedly said one thing and done another. He had made little to no effort during his time in recovery court, actually incurred another case upon release from jail to start recovery court, and now I received a warrant request today for conduct while in jail, waiting the sentence and having the other felony court case pending. So I'd ask the court to follow the recommendations. Thank you.
Thank you, Mr. Sayers. Please stand for the court sentence. All right, so we're here for sentencing on probation violation. In file 6457, you were on probation for resisting obstructing police by fleeing on foot from the police during a traffic stop. It's maximum 2 years. File 6765, you're on probation for fleeing and eluding 3rd degree habitual second, 7.5-year maximum. In that case, you fled in a car during a traffic stop, striking a police vehicle, both high-risk behaviors. In file 6764, you're on probation for delivery of methamphetamine, drug double, maximum 40 years. Possession with intent to deliver methamphetamine, drug double, maximum 40 years. Possession with intent to deliver cocaine, drug double, maximum 40 years. I mean, I've given you so many warnings, and we placed you in the recovery court program despite some of this high-risk behavior. You had multiple violations. We sent you to treatment, and you left treatment and then absconded supervision and had to get arrested. That's not even taking into account that it's alleged that you committed more than 1 felony while all that was going on, or while all this case has been going on. You can lay in that aside. You've been just out of control, and we have tried to give you every treatment tool in our toolbox. You know, so now I got to reach for the other tools. you know, what your attorney's saying is a great pitch at the initial sentencing, and I bought it, and I put you in recovery court. And you and I have had several conversations, you and Mr. Fagan, you and Nicole. And I don't know why it just isn't sinking in. And it's not just that you're using drugs. I mean, we've got deliveries, we've got possessions with intent, we've got fleeing from police, we got fleeing from the police in the car, hitting another car. They're high-risk behaviors. It places people in danger. Not just you, it places other people in danger as well. So taking all those things into account, in file 6457, I'm going to, that's an advisory guideline range of 0 to 11 months. I'm going to revoke your probation and sentence you to, let's see, you have another 85 days credit, I think, because we've been adjourning this. So I'm going to order that you serve 284 days jail, give you credit for 284 days previously served. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. That's 6457. In file 6765, that's the fleeing and eluding, third-degree habitual second. The advisory guideline range is 10 to 28 months. I'm going to revoke your probation and commit you to the Michigan Department of Corrections for a term of not less than 28 months, nor more than 7.5 years, exercising my discretion under the habitual offender statute to increase the statutory maximum to 7.5. You have credit for, by my count as of today, 225 days credit. Any fines and costs that were previously assessed remain due and owing in the amount of any unpaid balance. And that is a sentence within the advisory guidelines. In file 6764, on account of, well, I'm going to revoke your probation and any fines and costs and any remain due and owing in the amount of any unpaid balance. For the delivery of methamphetamine charge, the advisory guidelines are 51 to 85 months. The drug double would give me the discretion to double that to 102 to 170 months. I'm not going to exercise my discretion to increase the guidelines, but I am going to exercise my discretion to increase the maximum penalty under the statute. So for that case, Mr. Sayers, I'm going to commit you to the Michigan Department of Corrections for not less than 85 months, nor more than 40 years, with credit for 225 days previously served. That's a top end of the guidelines without the drug doubling. I believe that is proportionate, given his absconding supervision and leaving treatment. And again, I'm not exercising my discretion to double those guidelines. I'm leaving them undoubled, but at the top end. I am exercising my discretion to increase the statutory maximum from 20 to 40 years, however. On the count of possession with intent to deliver methamphetamine with the drug double, the advisory guidelines are 72 to 120 months. I would have it within my discretion to double that to 142 to 240. I'm not going to do that. However, because Mr. Sayers walked off of treatment and absconded treatment court supervision while all of this was going on, I'm going to sentence him to the upper end of the undoubled guidelines and commit you to the Michigan Department of Corrections for not less than 10 years or more than 40 years. Credit for 225 days previously served, increasing the statutory maximum by the drug double statute. And on the possession with intent to deliver cocaine, drug double, 40-year maximum, advisory guidelines 10 to 23 months. I'm going to not double the guidelines within my discretion, but sentence you again at the upper end of those guidelines at 23 months to 40 years.
credit for 225 days previously served. Exercising my discretion to increase the statutory maximum, however, not increase the guidelines. And again, top end of the guidelines is certainly proportionate in this case. All right, and Mr. Sayers, you have the right to file, you are able to file an application for leave to appeal if you wish on any of these cases. If you want a lawyer, I give you one, but you have to ask me within 42 days. So we're gonna hand you some paperwork explaining that process. One copy is for you to sign. If you want to take an appeal, the other one, we're gonna ask you to initial one in all 3 files so that we have a copy of it. And then we'll just have to rid them out or do it by video to deal with the pending cases, but I'll not have you in our jail any longer, sir. Good luck. All those sentences will be concurrent to each other, which I think is required by law on those files, but they're all concurrent to each other, all accounts, all the files.
Yeah, that guy looks like he's about 25, and he just got a long time in jail. I wasn't following him along how many years he just got. They're all concurrent. I think the longest one he got was at the minimum 10 years. So yeah, he's at least doing 10 years in jail. Yeah. Jeez. All right. Anyways, let's move on to the last one. Before we do that, Wixom and Sparkle Poots. Thank you both so much for the 5 gifted memberships. You guys are awesome. Welcome to the 10 new members. You guys are awesome. And yeah, thank you so much. Okay. Last case is Judge Garcia. You know, I love showing you guys Judge Garcia clips. She is in San Antonio, Texas. This one is a landlord-tenant case that, judge has to step in front of him. I feel like there's always one case on her docket where she has to tell everyone to stop talking. So yeah, let's go. Last case.
Not a problem. Zoe and Sarah, and we got both of them on Zoom.
Yes, I'm here.
All right, Miss Zoe. And then I got Miss Gomez. Okay, so Miss Zoe, first of all, I need to know, are you the owner of the property?
No, I'm not the owner of the property, but I am with her at this moment. Her name's Shirley Thomas, and she's the owner of the property.
Okay, so why didn't Miss Thomas file the eviction? Why are you filing it?
She does not live in San Antonio. She lives in Schulenburg. She's elderly and she doesn't travel very much. So I was the one that had to go and put in the court case.
Okay, so unfortunately, Miss Zoe, you are not the owner. You cannot get a judgment for a property you don't own. So
okay, I am partial owner. But if you still want to speak with my grandmother about this, she is available.
Well, I understand she's available, but I cannot give you a judgment for a property you don't own.
Okay.
That's my issue. So give me
Okay.
1 minute. Hold on. And as far as whether she can or not move around, that has nothing to do with it because we can e-file and we can appear via Zoom. So she honestly don't have to leave the comfort of her own room.
Okay.
So, but give me 1 minute.
One moment.
Okay, and your grandma is Shirley?
Yes, ma'am.
And your grandpa was Thomas?
Yes, sir. Yes, ma'am.
All right, so those are the owners of the property, so the style of the case needs to be changed to reference that. So at this point, I cannot proceed forward. The case is going to be dismissed. You can always refile if you like. If you need any additional information, you can consult an attorney and or you can obtain your own attorney to get any legal advice on how to file the case properly. Ms. Gomez, are you there?
Yes, ma'am.
Okay, Ms. Gomez, you don't own the property, is that correct?
No, I do not own the property. I'm also
Ms.
not a squatter. They know
Okay,
who I am.
nobody ever mentioned you were a squatter, so let's stop right there. Ms. Gomez, do you owe anything on this property?
No, so I did have a conversation with their grandma, Miss Shirley,
Okay.
and she said, yes, y'all can stay there. Y'all, as in me and her grandson, which she now doesn't want to have like a relationship with, as long as we pay the property taxes. So we all agreed like that's doable. Thank you, for your help, your kindness and your help. And at this point, from the 2 times that Zoe and her boyfriend have called the cops saying I'm breaking and entering into the property, it's been a mess. But Shirley doesn't even know who I am. So I really
I
she
do know
has a
who
lot of-
she is, and one thing is I can testify right now, my grandmother never said that. They never had that conversation, and Sarah is known for being exaggerating the truth.
Okay. Let's stop right here. So right now, the case is dismissed for a lack of style of the case. Ms. Gomez, I need you to understand that you and your husband, boyfriend, whoever he is, the grandson of Miss Shirley, Miss Shirley is the owner of the property.
Yes.
For whatever reason, she does not want y'all there anymore, and she don't need a justification. She owns the house. So if you don't want to walk away with an eviction on your record or your boyfriend or husband's record, then you might want to start looking at some places to move, because they are going to refile. It is going to become across my desk again. And if it's done correctly and you're in the property, you will walk out with an eviction. So
well, that's another thing. I'm sorry. We haven't been there since they've been threatening. So they've been very, physically violent. They've been, calling the cops, saying we're breaking and entering. Just a lot of excessive
We can't
stuff.
be physically violent if we've already called the police on her twice. That doesn't even make sense. We can't
Ms.
physically
Zoe, stop, that's enough. Have both of you, Miss Zoe, have you gone by the property?
I have been by the property today. The eviction notice that we left on the property is still there, so I don't believe she's been there since that's happened. But in any case, she's not allowed on that property.
Okay.
No, this isn't mom and daughter. This is the person that's representing the owner right now. This is the granddaughter of the owner fighting with the girlfriend of the grandson of the owner. So brother and sister relationship, but the person that showed up to court is the girlfriend of the grandson. I think that's the relation going on. I think that's it. All right. Anyways, there's only about a minute or two left of this clip. I am going to let it play out. I will see who we can potentially raid. I just looked about 5 minutes ago and no one else is live right now. So we might just call it a night and jump into Discord. Or Cousins. Yeah, Beaver, you might be right. Oh, Jay Hart, go check out Discord. I sent you a message about 2 hours ago. So go check out Discord. All right. Thank you, everybody, for hanging out with me tonight. You guys are awesome. Thank you so much for the super chats, the gifted memberships, the membership milestones. You are awesome. Thank you, MB, for the generous PayPal. Again, prayers to your mom. That's all I got. Let's go jump in Discord, and I will look to see again if there's someone that we could raid. If not, yeah, we'll just call it a night and see you in Discord. All right. You guys have a great rest of your evening. Again, thank you so much for hanging out with me tonight. I really do appreciate it. And I will see you tomorrow. Until next time, bye.
So it's up to you what you want to do. If you want to consult an attorney, you're more than welcome to. But for right now, the case is dismissed. Ms. Zoe, if you refile, I will entertain it when it comes across my desk. But in the meantime, if there's any restraining orders or any non-trespassing, I suggest y'all look into it before y'all react on anything, because this is a family matter.
Yeah.
And it looks like y'all need to take the emotions out and start worrying about what's best for all parties. And Miss Gomez, if y'all have moved out, great. More
Yeah,
power
we're out.
to y'all, and y'all go about y'all's business. If you haven't, then again, my words remain the same, okay?
Yeah. No, we are out. So one of the issues is that I don't know how to get a hold of them other than this right now, because they have been avoiding contact with me. So it's like, I don't understand how they would want to resolve this other than coming through here. It's just very excessive. Because
Okay,
if
and
it's
why are
came
you
out of
needing to
our,
get a hold of them? What do you need to give them?
oh, the key,
Okay,
the key to the
so
house.
Miss
We've already
Zoe,
changed the locks of the keys. We've already
okay,
changed the locks of the keys, so she doesn't need to give us anything.
all
I
right, well, there you
blocked
go,
her
Ms.
because
Gomez.
he's violent.
Ms. Zoe, I suggest you keep your comments to yourself. That's the
Mhm.
last time I'm gonna tell you that. When I
Mhm.
want your opinion, I will ask for it.
Thank you so much, Jay Hart. I appreciate it. Everyone, go check out Jay Hart's channel. Thank you so much for the 9 months. That is awesome. I think Heather just hit 9 months. I think you might be the second to hit 9 months. That is awesome. Also, Chris Barton. Good to see you, Chris. I hope you're doing well. I really do, Chris. I hope you're doing well. All right. Now I'm actually out for real. I'll see you guys in Discord. Until next time, bye.
All right, Ms. Gomez. So as of right now, you do not need to return the keys. So you'll go about your business, okay?
Okay.
All right. Thank you, guys.
Okay. Thank you.
Thank you. All right, let me